Hi, this is Ray Kerlick from the law firm of Wadler, Perches, Hundl, and Kerlick, and today I'm talking a little bit about the process of selling property that you own. It's a complicated process, and we certainly would always recommend involving an attorney in that process because, as you'll see, it's a little harder than simply making an agreement with someone to sell the property, and this is an issue that we deal with all the time. The technical instrument that actually results in the transfer of property from one person to the other is called a deed. And most of us are familiar with that concept. To kind of be real familiar, it requires something in writing signed by all of the owners. And so when I say all of the owners, typically that means figuring out who are all of the owners of a property, who has title to all of the assets in the property. That deed has to be recorded at the courthouse, not necessarily for the purposes of being effective, but certainly for the purposes of creating a chain of title. So the best way to think about a chain of title is to kind of think about what we sometimes hear on TV shows when we talk about a chain of evidence. A chain of evidence is basically to kind of confirm that this piece of evidence went from one person to the next person to the next person, and that it was documented every step of the way. That's absolutely the same way that title to real property works. We need to make sure that everyone, all siblings, all heirs, all people that may have any interest, including mineral interests and related interests, have agreed and have actually signed the deed in order for it to be effective. Now, are there such things as partial transfers? Absolutely. Most of the time, they're unintentional. What that means is I've reached an agreement with someone to purchase a property, not realizing that they only own a fractional interest in that property. You've now paid them for the entire value of the property when you're only getting a portion. The other owner potentially has the ability not only to join you in possession of that property, but to potentially partition or separate your interest from his interest, thereby leaving you with certainly less than what you bargained for. What is the more traditional way to do that? Well, we typically do that by way of what's called an earnest money contract. Earnest money in that situation is a strange term. The term means that I am providing money to someone to show that I am in earnest about purchasing their property. So what we often, lawyers often call this is an agreement to agree. So this is a contract to actually purchase property at a point in the future. Well, what do we call that point in the future? We call it the closing date. So what happens on the closing date is the deed that we talked about up here, along with typically a lot of disclosures and other related documents get signed. In addition, there's the transfer of the funds that actually takes place on the closing date. And to the extent that there is lending or financing involved, those finance documents also get signed on that same date before the money is transferred from the bank to the seller. We get a lot of questions about title insurance. And again, title insurance isn't required by the law, but it is typically required by lenders, banks, and other people who want to make sure that their interest in the property. And so for a bank, their interest in the property is to make sure that if you don't pay, they can foreclose and get the property back. That's handled by the title insurance company. The title insurance company prepares a title commitment, which basically shows any issues that may arise in the course of their looking at this chain of title, right? So they're going to go down, search the courthouse records, and make sure that there isn't a gap or a missing fork in the chain of title. That earnest money contract will also provide for who the title insurance company is, when the closing date is, and then typically it will also provide for who pays various costs, things like a survey of the land. The survey of the land is basically having a professional come out and actually stake the boundaries, the actual boundaries of the property. There's also things like escrow fees, obviously the title insurance fees, attorney's fees related to the preparation of the deed that we talked about, and other documents that are associated with that. All of those things get divvied up in the course of signing the earnest money contract, so that when we go to the closing, the closer or the person at the title insurance company who's doing the closing knows exactly who to charge it to. They typically prepare what's called a closing statement, what used to be called a HUD 1, and that will show exactly who is paying what and to whom it's being paid. And typically at the end, there'll be an amount that's owed by the purchaser, an amount that's being received by the seller. So that's, again, there's a lot of complexities in all of those documents. The closing statement typically includes several hundred lines. So each of those things can be something that you need to have reviewed and take a look at with someone that you trust to advise you on those kinds of things. So if you have those kinds of questions, please give us a call or visit us on the website at www.wphk-law.com. Thank you.